Good afternoon, everyone, and welcome to the seventh edition of Dispute Resolution Dialogue Series, a series of conversation dedicated to exploring key legal and policy challenges shaping the landscape of arbitration and dispute resolution. Today, we have with us Madhavi Divan, a senior advocate at the Supreme Court of India, and Prashant Narang, Deputy Director, Research and Programs at TrustBridge. They will be sharing their insights on PSU litigation strategies. So let's dive right in. Over to you, ma'am.
All right, thank you. And good afternoon to everyone, and thank you for being here. I will try and share my insights based on my own experiences insofar as PSUs and government departments are concerned. It so happens that I served as a law officer for the Government of India for 4.5 years between December 2018 and June 2023. And as a law officer, I mean an additional Solicitor General. And in that capacity particularly, I had the opportunity to represent several PSUs and government departments, including in arbitration. And also arbitration, Section 34, Section 37 challenges in court. So what I will share with you broadly is what is my experiences, and I will share a few of those with you, which perhaps will speak for themselves, and you will be able to appreciate perhaps the malaise that plagues arbitrations. And of course, some of this plagues arbitration generally in India, but how PSUs in particular are impacted. And perhaps that will also give you an insight into what prompted the government to come out with that very controversial notification, basically, wanting to opt out of arbitration. Now, there are 2 or 3 instances which I'll share with you. And the first one that I can think of is it was a power company that I was appearing for. And it was an arbitration before a pretty star-studded 3-member tribunal. They were all very accomplished retired judges of the Supreme Court of India. And I have, of course, had the opportunity I had had the opportunity of regularly appearing before all of these 3 judges before they retired. And they were just outstanding judges. But something changes when judges retire and become arbitrators. So my experience in arbitration has been very, very different before the same adjudicators, as it were, in court and then in arbitration. Now, this particular arbitration relating to this, I was representing the respondent, which is a power company, a PSU, and I found, to my utter surprise, that this tribunal was appointed. It was the 4th arbitral tribunal arising out of disputes, according to me, the very same set of disputes from the very same under the very same contract between the parties. So there were already 3 other previously appointed tribunals. Some of them were retired judges, some of them were technical people on those tribunals, and some of them, a couple of them, I think, were still pending at the time. And this was the very same contract. It was in respect of disputes which actually had already arisen at the time those other arbitrations had been invoked. So you had a set of 4 arbitral tribunals under the same contract. It was just that, there might have been successive disputes, but a lot of these disputes had already arisen when the other tribunals had been constituted. So I could not, for the life of me, understand. It really baffled me as to why all of these could not be clubbed under one arbitral tribunal, so as to have some kind of certainty and predictability and closure. So I raised the point of jurisdiction, and I said, that this is ridiculous. It's going to lead to all sorts of, possibly contradictory outcomes, and we can't go on with this. So in the course of my research, because I was just a little curious about why this was happening and why a claimant would do this. And, I came across two things. One was, of course, a single judge's judgment of the Delhi High Court judgment, which strongly deprecates such a practice. So obviously such a practice had been in vogue. It had been judicially noticed in matters, and it has been strongly deprecated, and the court in fact invoked Order 2, Rule 2 to say that, look, this is absolutely not done. The court could not have, the arbitral tribunal rightly did not go into the matter in that particular case. Now, I also found a very scholarly article from a French expert who, as it happened, had appeared in several arbitrations internationally, where there were state bodies and state, the equivalent of PSUs, state departments which were involved. And he has written extensively about this practice, which he describes in very strong terms as an abuse of process by claimants, particularly acting against state departments or state companies. And it seems that this was a calculated and deliberate move to, which was meant to prejudice the other side, to exhaust them with, multiple claims, mulct them with, the cost. It's a costly affair. You have to divert officers to attend to multiple matters, and also the incentive for a claimant in such a case would be that there would be uncertain or contradictory outcomes in the different series of arbitrations, which would, be a sort of, fertile ground for challenges, etc. So the idea of this policy of fragmenting disputes is obviously something which I had not encountered before, but apparently it is not so uncommon a practice, and this particular expert calls it a serious abuse of process. So I raised these things before this arbitral tribunal, which, and I had a lot of respect for these former judges of the Supreme Court. And we filed written submissions. I tried to argue it in very strong terms. But the general sense that I got was that, look, no, we will decide it. We are not rejecting your point. Your point is well taken, but we are going to decide the entire matter on merits, and then in the process, we are going to also decide this issue which you are raising. So I said that, look, what is the point of going into merits? Because if you're going to go into merits, again, we're falling into the same trap of having, possibly contradictory outcomes. So why would you go into merits? Why would my client have to waste that kind of time and money and energy over something which is quite unnecessary and which could have been consolidated before one arbitral tribunal? And much as I tried, and my written submissions, I think I have access to them, they were rejected. And of course, predictably so. And, I eventually, I said to the client that I have no faith in this tribunal. And if this is the manner in which, they should have ruled very specifically, rather than, postponing this to some subsequent point in time. And I was very disappointed, and I opted out eventually of that arbitration. But this gives you a little bit of an insight into, what happens when the very same people who are actually, when it comes to government and PSUs in court, we find that, judges are very accommodating, and they give you a longer rope because they understand that there are certain, there's red tape, it's difficult getting instructions, it's difficult getting assistance. They understand all of that, and therefore, it's very normal that, you get a little bit of a long rope. I don't know what happens in arbitration. My experience has been very, very different. So now the other point which I will mention here, and perhaps this is something that is true of a lot of arbitration, even generally in India, not necessarily involving PSUs, but as PSUs, when I've represented PSUs, and at that time, we have borne the brunt of things like, now it's become very part of, it's the norm now for arbitrators to sit virtually and conduct matters virtually. Now, when it is a sole arbitrator, no problem with that. I think it saves a lot of time. It's very convenient, all of that. But tell me, what happens when you have three arbitrators? And they are all, in different cities. They are sitting in a tribunal, which is just, three different separate boxes on a screen that you see. And it's difficult to make eye contact with all three at one time. It is difficult to, in many ways, it defeats the purpose of having a tribunal, because a tribunal, a panel, is meant to converse and to deliberate in real time, not simply because they go into those separate conferences there, or they talk to each other once in a while on the phone. To my mind, the purpose of having a tribunal of three members is so that they are able to interact in real time. They're physically sitting together. And it's one thing for a council to be appearing virtually, but it's another thing for a tribunal of say, three members to be appearing separately without any continuous interaction with one another. So I find that very problematic. The other thing is that, there have been instances where, for instance, that matter is still pending in court. I'm appearing in the Section 34 challenge. But I was a little surprised to see the quality of that particular award, because, again, the author of the award is someone I do have a great deal, I did have a great deal of respect for when, I appeared before him as a judge. And I was a little surprised at the quality of the award. And I was told that no, this is what happened was that the arbitrator was so busy with other matters. I said, what do you mean? All popular arbitrators are busy with other matters. So he said, no, this is the briefing advocate. He said, look, while the arbitration was being conducted, the arbitrator was on multiple screens, and this counsel could hear the cross-examination being conducted in a separate arbitration at the same time, and he could hear the counsel's voices and recognize the counsel's voices in the other arbitration. So you have multiple arbitrators. We know of advocates who juggle different courts at the same time. But, now it's the arbitrators also, some of them seem to be resorting to this tendency. So as a result, you see the quality of the arbitration is compromised, and, there is an inherent lack of professionalism. So on the one hand, we talk of ourselves as, aspiring to be a global hub for arbitration. But, if you have this kind of practice, then it is certainly, we are nowhere close to it. You see, the other thing that I would like to mention here is the kind of delays that we encounter in the court process, because ending the arbitration being carried out within a certain time frame is not an answer by itself, because the point is there's going to likely be a 34 challenge. There will be a 37 challenge. Eventually the matter may land up in the Supreme Court. That will also take some time if it is entertained. So there was a case, in fact, I had appeared in some capacity in, it's called Chopra Fabricators. There are a series of short orders which the Supreme Court has passed, where they have deprecated the kind of dependencies that you have in the high courts of arbitration matters. So this was, I think, it was the Allahabad High Court, where there are thousands of pendencies, some on Section 11, Section 34, and some of them, a very large number of matters under the 1940 Arbitration Act. So, that is where we are. And, it's a pretty depressing statistic. Now, and this is while, individual judges work extremely hard. I think in our country, the kind of work that individual judges have to put in is phenomenal. I think that must be acknowledged. Nowhere, I think, in the world are you burdened with this kind of, caseload. But at the same time, I think systemically, there is something which is very, very amiss and which needs to be fixed. So, I mean, look at, for instance, the Delhi High Court is one of our very, very good high courts. And yet you have matters, say, challenges from awards of 2011, 2012, still pending, and still at the 34th stage after, 13, 14 years. So this is, again, very, very problematic. I'll give you one example of how, this was against, actually, it was against a port trust, where I had appeared, and this was before the Supreme Court, and we were heard over several days, and eventually we succeeded before the Supreme Court. And this, it was a 2011 or 2012 award. So after this must have been in 2022. So about 10 years, it attained finality, or so we thought, and that was going to translate into at least 1,000 crores for my client, and interest over and above that from that time. So it was a very, very substantial amount of money. And so, everyone was rather pleased till, of course, lo and behold, a few months down the line, not only did the other side not pay up, but they filed a writ petition in the High Court, in some oblique way to sort of derail the execution of the award. And that writ petition was dismissed. They went in appeal. They lost before the division bench. Eventually, the matter comes up in the Supreme Court, and it comes up before a vacation bench, and it is stayed without too much of an argument from the petitioner. It is stayed. And so I don't know what the status is, because I do not appear in the matter anymore. But, this is how something which is so hard fought and so long fought is defeated by, some oblique sort of litigation strategy or the other. So, it's a real dampener. And you have, when matters are, prolonged for so many, many years, what tends to happen is not just the physical, the cost of it, not just the time wasted, but we don't seem to put a cost on the human resource cost, because I have encountered officers who say that, look, we are not able to do our regular job because we have to attend to this arbitration, or then the matter goes to court, so you have to attend it in court. So they are also taken away from their regular work. So this is also, I mean, a cost should be put on this as well. It's not just the litigation cost. It's much, much more than that. It's you're not able to build up the efficiency and progress of your corporation if you are going to be embroiled endlessly in litigation. So, these are some of the issues. Now, for instance, another example which I will mention is recently I've appeared in, and it is actually still pending, but interesting from a PSU standpoint, because we were for a PSU, we are for a PSU. The Competition Commission has, in 2017, held the PSU guilty of abuse of dominant position. And they're the complainants, or the informants, as we say in the competition lingo, were PSUs themselves. So we actually suggested that, we must go in for the internal, it's called AMRCD, the internal mechanism, PSU to PSU, to try and resolve the dispute. But of course, the Competition Commission says, no, it's a competition issue. So now what is very interesting here is that the judgment of the Competition Commission doesn't say there's any there's no finding on adverse effect on competition at all. Right, so it is in effect, according to us, it's an in personam issue. It's not an in rem issue. It doesn't impact the market as a whole. So should it not be resolved internally, PSU to PSU, or should you be fighting endlessly for years? And this is it started in 2011. So these are interesting issues which come up. I'll take a couple of more minutes just to mention that within the court system, one of the other problems apart from delay is that you have this kind of judicial uncertainty caused by successive interpretations, one after the other, which changes the interpretation of the law. For instance, on Section 34, we've seen that. Section 11, we've seen that. We've seen recently NM Global 1, then 2, then 3. So there's a huge flip-flop over there, which is not something which is a very happy thing for litigants, and it doesn't inspire much confidence in the system. And the legislature, for its part, has been making amendments to try and plug those uncertainties and those gray areas, trying to narrow the scope of interference. But at the same time, the judiciary is faced with situations where they have to interpret the law, and that leads to perhaps further expansion and further uncertainties. So recently, a few months ago, in a matter, we were trying to, my colleagues and I were trying to, draw up a difference between the Section 34 as it was pre-2015 and Section 34 as it has been interpreted post-2015. And after making these very elaborate charts, which try and capture how the courts have interpreted it, we came to the conclusion that it's not too different. So what was the purpose of this whole exercise of a legislative amendment, etc.? So, given all of this, I do understand where the government is coming from when it is at a certain level eschewing arbitration. But having said that, I think from a standpoint of the spirit and the policy of on the ease of doing business, it doesn't augur well if government itself throws up its hands and say, we don't have faith in this system and we are not going to, what is the private sector going to do? So I think it is also for government equally to, partner with the private sector, with the legal fraternity in trying to build up a system where arbitration can inspire confidence, and it doesn't require very complicated fixes. I think we are, in fact, it's a matter not so much for lawyers to do, but entrepreneurs to do, because, in India, we have so much potential in terms of, well, the fact that you have hundreds of lawyers being churned out of law schools every year. These young people are skilled and smart, and they are going to require work. So here is a lot of potential for work, but they need to be channeled. They need to be trained. They need to be specialized. That is something that perhaps law firms can take on. We can create infrastructure. We must, create pools of alternative arbitrators, whether specialist or, from the legal fraternity. But it's really important to give that training, to create infrastructure. And I think that if this can partner with, somehow the judiciary in ensuring that, look, there is a seamless passage and a quick passage through the courts, whether in 34, 37 and out from the Supreme Court, then I think this can be a really, really worthwhile project, which government has to take some initiative in this department. It's not enough to say that, look, we don't have faith. So I think broadly, these are my thoughts and my experiences. And of course, if there are any questions, I'm happy to answer. Thank you.
Ma'am, I think we should take questions for you first, just in case if there are, because otherwise you have to leave. So,
I have a question. Thank you for that talk. It was very, very insightful. I'm going to proceed to the right. I like the point that you made about how virtual arbitrations are difficult, because the idea of a tribunal is for people to be able to have deliberations. But there's also a great deal of how being able to participate in these proceedings virtually sort of democratizes the process, makes it more accessible for, say, smaller businesses that are doing business, say, with someone who lives in another city, are able to, for instance, take up their disputes. And the idea that having things like breakout rooms helps you have the same kind of conversation that, for instance, you and I are having right now. So what do you think exactly it is about the actual physical presence of a tribunal being together that sets it apart?
All right. So perhaps I didn't make myself clear enough. I totally agree with you that technology must be harnessed to ensure that people don't have to travel long distances, etc. And we waste a lot of time in traffic. And you're right, as far as access is concerned, I would say from a lot of this is one area where women particularly young women with young families, for them, they can appear in arbitrations, because, well, the timings are a little more certain, and two, of course, that you should be able to appear virtually. What I was saying is only from the standpoint of, panels of arbitrators. I think they should be sitting somewhere together. Whether it's virtual or it's otherwise, they should be sitting together. I don't think a breakout is adequate. They usually, I think, communicate through, in my own experience, once in days and days of arbitration, I have seen them speak on the phone. When they mute each other and mute the hearing, and they speak on the phone. But frankly, I don't think that is adequate, because there's a reason why three of you are appointed, as a panel. You're meant to be interacting with one another in real time, and there is something to sitting together. So I think counsel, you appear virtually, no problem. Sole arbitrator, no problem. Do it entirely virtually, no problem at all. But I think when there is a panel of arbitrators, they've got to be sitting together. That's
Right,
my
experience is different.
Yeah.
Thank you. We have a few questions from the audience as well. The first one is, actually, Hardesh, why don't you go ahead?
Okay, hi. I hope I am audible.
Yes, you are.
Okay, so ma'am, thank you for the address. It's very insightful. I have a few observations that I have noticed. Just to introduce myself, I am an assistant professor of law at Vinay Commission's Law School in Chennai. So what I have been noticing after speaking to my friends who practice in this field of arbitration is that, especially in government departments, what they're seeing is there are a lot of conniving officers who are basically fixing arbitrations. So what essentially happens is that you approach a particular officer in a government department, you raise a claim, and in corroboration with the person that you fix the arbitrator, both of you agree on the arbitrator as well, and the arbitrator gives you a definite sort of a award that is pre-decided. So in that sense, I think there's a scope of corruption also now that has come in as far as arbitration is concerned, especially in government departments, because in private entities you can have a check on this because there's a hierarchy and you have to report to the hierarchy. But in government departments, if there is some adverse order passed against you, perhaps it is considered like the cost of doing business maybe, and essentially you are not responsible, or the company that you're running is responsible. You are personally not responsible, and it does not become a part of your ACR per se. Also, what another observation that I have is on the general concept of arbitration.
Could we just request you to be a little concise?
Yes,
We
yes.
have a few more questions.
I want your comments on this. I have this concept that is brewing in my head at the moment. Is that sometimes we discount the very democratic concept of dispute resolution itself. When we look at PSUs, essentially they are entities that are owned by the people, right? And one of the aspects of democracy is that you keep a check on the government, and the government is essentially running these PSUs. So if we go into dispute resolution methods which are opaque and beyond citizen scrutiny, does that not impact the very concept of democracy itself? Because keeping a track or keeping a check on these disputes which are essentially opaque is not possible for the average citizen. Whereas if these disputes were out in the open, they were in court, then perhaps there would be some sort of citizen scrutiny as well. So if you can offer any comments on that.
Well, on your first point, on possible corruption at that level, well, I am personally, I speak from my own experiences, and, I mean, it is depressing what you say, but I mean, yes, I'm willing to believe that does happen. There is also, you see, there are sometimes, yes, PSUs, there are different issues which come, for instance, which doesn't happen in private parties, where, for instance, where, or it doesn't happen so much anyway. The choice of counsel, sometimes it's for the right reason, sometimes it's for the wrong reason. That happens, and that sometimes can compromise or impact the quality of the advocacy. So, I mean, that is something, yes, I have seen that choices are not always entirely on merit. I think that is problematic. But there was one solution which somebody had suggested, and which actually led to more red tape, which is that no, you must go through a central, that it must be scrutinized at a higher level, and that takes so much time, to get an approval. So if you, for instance, if you've got a matter in court and you need to, take a call quickly because you're on caveat or whatever, and you realize that the matter is coming up tomorrow, by the time you make your choice and you get that person prepared to argue, it's not effective enough. So, I mean, government and PSUs, they face their own problems. Now, on opacity, I think, government itself has opted out of arbitration. So I think you should see that also. But between PSUs, they want to, try and resolve it internally. And I think that's not a bad thing at all. I think they shouldn't be wasting public money in fighting long litigations.
Okay. So I'll start with my presentation. The way I have structured my presentation, I will look at three sources. One is the Law Commission report of 1988, which is the 126th Law Commission report, which talks about public sector undertakings and their litigation behavior. Second is our own research. We conducted a qualitative study. We conducted around 36 interviews with stakeholders and tried to understand PSU litigation behavior. And third is a recent office memo of 4th April, which was issued by a Department of Legal Affairs, Ministry of Law and Justice. I'll come to that in the end. So the Law Commission report talks about PSU litigation behavior. The context was rise of PSUs in post-independence. And so why did PSUs become the largest litigants? That was the question that Law Commission was looking into. They were created to serve welfare state functions, but they were quickly mimicking private firms in litigation style. So courts saw PSUs as prodigal with litigation and stingy with justice. Judges repeatedly criticized PSUs, wasteful litigation, and also avoidance of accountability. What the commission notes is that PSU officers routinely avoided decisions. They let courts decide. And so what it results in, and the commission calls it appealitis, which is about routine appeals being filed up to the level of Supreme Court. The commission also notes that it's basically a fight between Goliath and David Dwarf, where state is the Goliath and citizen is the dwarf. Citizens faced asymmetry because state, in this case PSUs, have unlimited resources backed by citizens' money. It's the taxpayers' money which is being spent on litigation against the citizens. And so that's the irony. For public officials, for PSU officials, it's safer to litigate than decide. There is fear of accountability. Officers push disputes into courts because they think that they may be scrutinized, their decisions may be scrutinized later. The commission also notes that it could be because of the must-win attitude or some ego issue, sometimes against other employees and pensioners. This is with regard to service matters. And also that there is no personal cost to those employees, to PSU officials. The cost is borne by exchequer and not decision makers. So there is no personal incentive or disincentive as far as officials are concerned who make those decisions. And so this culture is not accidental. It is structural. It is inherent. The way systems, the way incentives, play out in this ecosystem. So there is no accountability. There is prestige mentality, and so that leads to endless litigation. For PSU or for PSU government, excluding the tax, the Law Commission recommended mandatory arbitration. They recommended that there should be panel of retired Supreme Court or High Court judges with fixed fees. The courts should be empowered to dismiss suits filed without prior arbitration. Award should be final, and appeal should only be filed with law minister's sanction. That was something surprising that I see in this report. But also, we should be mindful that here they are talking about the disputes between two PSUs. So what the commission recommends is a structural redesign. And so they say that there should not be free litigation, but the dispute should be funneled into internal processes or arbitration. And so arbitration should be the norm. Court's role should be limited, and PSU officers and lawyers should face real accountability. The commission also recommends that there should be a federal legal cell. It should be a central body with judges, law officers, PSU executives for litigation strategy and coordination. They also recommend a parliamentary committee on litigation to be constituted, which would review wasteful expenditure, hold officers accountable, and there would be annual reporting of litigation costs. The report's ambition was to institutionalize conciliation across all litigation types. The legal cell would centralize strategy, while the parliamentary committee would provide democratic oversight. So the overall vision was to embed a culture of fairness. Now we come to our research. As I said, that we conducted a qualitative study with, we interviewed 36 stakeholders. This included some PSU officials, industry members, retired judges, arbitrators, also arbitral institutions, representatives, etc. So the question that we delve into is, do 1988 concerns still persist today? And we find a lot of those concerns, they do still persist today. PSUs almost always challenge adverse awards. Every award is challenged. The appeals reach Supreme Court. Even for petty amounts, appeals are filed as a matter of principle. Continuation of delay applications are routinely filed. And this is the modern form of appealitis, the term coined by the Law Commission in 1988. So stakeholders confirm that PSUs will rarely accept an adverse award. So appeals are not exception. In fact, they are the default reaction. So the question was, why are appeals filed? And stakeholders tell us that it's because of fear of vigilance. They fear that there can be a vigilance inquiry, there could be CAG scrutiny, there could be CBI inquiry. And so they avoid settlements to prevent future allegations of bias or corruption. Settlement, in fact, is seen as career risky, and appealing is the safe bureaucratic option. Appeals, they feel, also prevent setting precedent for future disputes, and hence they should not be, they should be, and so settlement should not be resorted to. Officers see litigation as a shield against scrutiny, and filing an appeal is basically an evidence that due diligence was undertaken. So this creates a culture where commercial common sense is overridden by self-preservation. So apart from that, what are the other structural weaknesses in terms of legal capacity? So the way lawyers are chosen, especially in-house lawyers or empaneled lawyers, PSUs often go for cheapest lawyers and not the best fit lawyers. The instructions are sometimes delayed, or lawyers are briefed too late, the files reach them very late. Some lawyers, some stakeholders tell us that they have very good institutional memories because often there is a long paper trail, but many stakeholders also tell us that the record keeping is poor, files are dispersed, and there are transfers, which means that the public officials, the PSU officials that are in charge of the matters, when they are transferred, it breaks the chain. And so the new officer who is joining is not very well aware of the disputes and its nuances. The contract drafting is poor, and so if there is a mistake, the same mistakes are repeated across projects. Approvals take months, and PSUs are often slow to invoke arbitration. So unlike private entities, PSUs often lack institutionalized legal preparedness, and so because their processes are not as robust as private entities. Which means that these delays add interest cost. Payouts are sometimes double or triple the original claim. Appeals are used deliberately to buy time, hoping for cheaper settlements later. As we know that Section 34 challenges drag on for years. Even in Delhi High Court, which is considered to be relatively more efficient, the challenges drag on for 3 to 4 years. Government logic is it's cheaper to pay later, and so hence there is preference for deferral. In fact, the same logic also shows up in the office circular of 3rd June, which was recently, which, I think Hatej had just mentioned about, that the government wants to go for litigation and not arbitration because the longer it takes, the more the delay, hence the payment would be deferred. So delay is not incidental, it's in fact calculated tactic. It may be costly to the exchequer because, when a payment is done after longer time, then it may be with huge cost in terms of the interest. But it's rationalized within bureaucratic logic as a way to protect public funds in the short term. There have been settlement schemes that were announced, but there was partial uptake and mixed impact. They were not very successful. The Office Circular of 3rd June 2024 pushed for mediation as the default action for all procurement disputes. And it also pushes for institutional arbitration only for small claims. And for all disputes that are over 10 crores, it pushes for litigation. So litigation then, comes back in the picture, and arbitration is no longer the default setting for large claims. We also get to know from stakeholders that PSU officers favor in-person hearings over virtual hearings. PSUs remain bad customers for institutional arbitration in the sense that they don't respond to calls for prompt hearings, prompt filings, timely filings, etc. Key judicial rulings in the sense that the questions that are already settled are again invoked, and so they exhibit ignorance of those key judicial rulings. Reforms have worked only partially. For example, timelines have reduced case length. So we're talking about Section 29A, but they have also not been very effective. So what we see is the deeper culture of appeal and delay persists. So we see a lot of similarity between what the Law Commission noted, and the situation is very similar even now. So PSU adjudication, or their PSU adjudication strategy, is a feature of basically a structural behavioral issue, and it's not episodic misconduct. The causes are fear of scrutiny, weak preparation, and rigid bureaucracy on the red tape. And it results in waste of public funds. It also burdens the courts or the arbitral system. And it has, a question. It leads to question of credibility, because private parties then don't view PSUs as credible commercial counterparties. So the reform should target officer accountability. There should be cost sanctions under Section 31A of the Arbitration Act, which means that if an appeal is frivolous, or if a case is frivolous, the claim is not meritorious, then there should be cost imposed on the party. And ADR should be institutionalized. So interestingly, the Office Circular of 3rd June 2024 talks about institutional arbitration over ad hoc arbitration, but at the same time, it does not mandate that for large claims. It only reserves it for small claims. Now we come to the Office Memo of 4th of April 2025, which was issued by Department of Legal Affairs. It applies to, so there is a lot that this Office Memo talks about, especially, and there are similarities with the Law Commission report. For example, it talks about constituting legal cells in all ministries and government departments. This is something similar to Law Commission's recommendation of constituting a federal legal cell, a central body that thinks about the litigation strategy. However, as far as CPSEs or PSUs are concerned, the circular is applicable only with regard to the arbitration matters. So it talks about the clause design, but it talks about clause design in the context of the last year circular, 3rd June circular. And so it kind of endorses the last year circular, and it says that mediation should be the default option, and then institutional arbitration or litigation subject to the size of the claim should be chosen, and the data should be reported. And for that purpose, one significant recommendation that this Office Memo makes is Government Arbitration Portal, or GAP, which would generate a unique case ID for each arbitration matter. It asks for all arbitration-related data to be uploaded, and so it would be updated regularly. And there will be a quarterly portfolio review of all domestic and international arbitrations. So to conclude, we see that the PSU litigation behavior has not really changed much. PSUs remain appeal happy, delay driven, resistant to ADR, and they're shielded from accountability. We need a coherent litigation policy. So the Office Memo of 4th of April is not enough, because it doesn't talk much about what CPSCs or PSUs can do to rationalize their appeal behavior, to rationalize their docket size. And so we need also external sanctions such as costs, and we need a culture shift, so that PSUs can become a virtuous litigant. So this is it. Open to questions.
We have a few questions from the audience here. So what safe harbor guardrails could let officers settle without CDCs, CNG, CBI exposure? So how could they be safeguarded to ensure that they are not put under the radar, but not appealing the matter?
So the office circular of 3rd June 2024 had a suggestion. It suggested that high-level committees should be constituted. So basically, what it means is that the settlement decision should be outsourced or delegated to a separate committee that would take decisions, so that the officers, the concerned officers, should not have the burden or should not have to make those decisions. So the committee may have, and the circular kind of keeps it very flexible. So the PSU or the department can, come out with their own, their rubric or their framework on how to constitute that high-level committee, which would then have decision-making power to go for settlement. So both in terms of process, in terms of constitution of the high-level committee, as well as what would be a good threshold for settlement, both these decisions or both these rubrics can be developed by the PSUs internally. And so there is no high-level guidance in terms of what this rubric should be. So which means that it is left as flexible. However, having said that, we don't know whether this model has been successful anywhere. So my suggestion would be that the government should do a pilot, maybe in a department or in a PSU, and see how it works. So there needs to be a study of how it works, where are the challenges, and then how those challenges should be tackled. So basically, it requires a pilot.
So on the same lines, should internal approvals require a cost-benefit memo comparing appeal versus settlement?
So that's a very good question. We don't know much about it. We did ask that question to stakeholders, and one of the stakeholders told us that there is some sort of rubric, some sort of threshold. So the PSU officials need to answer that question whether there is merit in filing that appeal. But it is about legal justification, and often whatever justification they give in terms of the merit, it's not questioned. So it's not really a cost-benefit analysis, but it's more to do with legal justification. And since the presumption is more towards that appeal behavior, and so the justification is not questioned whether that was a good justification. So even if it is not cost-benefit analysis, even if it is legal justification, and that's exactly what we see in our findings, that sometimes even legal questions that are settled are invoked again, are raised again. So which means that the justification is not really taken seriously. I mean, the justification, even if it is not very serious justification, is not questioned.
So in that case, if there's a mandatory legal co-sign-off, would that reduce defensive appeals? Do you believe that would happen?
So the high-level committee, which is prescribed in the last year circular, they say that you may choose to have, for example, retired judges or a person who has an understanding of law, so that they can then make a recommendation of whether this is a fit case for appeal or not.
Okay, thank you. Do we have any questions online? And this is
Okay. So thank you, Ms. Madhavi Divan and Dr. Prashant Narang, for a deeply engaging discussion on the complex yet vital issue of PSU dispute resolution. With that, I'd like to thank all of you for being part of this session.